Welcome to the Northern Institute's People Policy Place webinar with Steve Rogers. Firstly, I'd like to acknowledge, to begin, we'd like to acknowledge the traditional custodians of the land on which we meet today. For the Northern Institute in Darwin, it is the Larrakia people. We pay our respects to their elders, past and present and future, and extend that respect to Aboriginal and Torres Strait Islander peoples joining us today. Without further ado, I will ask Dr. Steve Rogers to begin the webinar.
Morning everyone. Thank you, Katrina. I'd just like to say what a great pleasure it is to talk to you all today. I would also like to start by acknowledging the traditional custodians join Katrina in that. So before I start, I want to make it very clear I am not an IP lawyer. And as you'll see as we work through the webinar, IP involves some fairly complex legal issues. So I'm not an IP lawyer, but I'm somebody who's had a lot of experience in dealing with IP management and IP protection. So on that basis, let's go forward. I will try and keep my talk to about 40 minutes and hopefully that will allow plenty of time for any questions at the end. And of course, the Office of Research and Innovation is always here. If you have any questions, you want to come and talk to us about IP protection or IP management, we're always here to talk to you. Okay, so what is intellectual property? Okay, so intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. And there's a link there. I believe this presentation will be made available to everybody. So there's a link there if you want to investigate further what IP is. Now, in terms of the context of the work of CDU and the work of the Northern Institute, in 2015, the United Nations declared that intellectual property also includes cultural property, such as historical sites, artifacts, designs, Indigenous languages, ceremonies, and performing arts, in addition to artwork and literature. Now, whilst that definition is there from the UN, one of the critical issues that has not been resolved moving forward is how do we resolve that definition of Indigenous people's rights and IP with our current IP legal structures. It's certainly an issue moving forward, and it hasn't. For instance, you could imagine an Indigenous language that has been around for 50,000 years. That Indigenous language will continue to be around into the foreseeable future. If you want to protect IP legally, most legal mechanisms for protecting IP actually have a time limit on them. So how do you put a time limit on something that's been around since the dawn of time? So why do we want to protect our IP? Okay, so by protecting IP, what it does, it gives you as the owner the exclusive right to utilize that intellectual property. So one of the reasons we might want to protect IP is because it has commercial or market value. We want to sell a product. We want to copy a piece of artwork and sell that commercially. But one of the things when we're looking at protecting IP for commercial or market reasons is we need to be absolutely sure that that IP has commercial value. So we need to undertake a detailed market analysis. We need to understand, and I'll be presenting an example, a real life case study of patent protection in a minute. I'll give you an example of protecting IP with very little value. Quite a few years ago now, CSIRO undertook an audit of all of its patents. Now, if you're granted a patent, you have to pay an annual fee to maintain the validity of that patent. And what CSIRO discovered was that they were spending nearly $1 million a year on patent protection and actually earning almost nothing from those patents. So there's a lesson. People will go out there and patent and spend a lot of money on that, but if you're not actually making money through commercial exploitation of that patent, then you have to ask yourself, why are you doing that? In that case, CSIRO actually put a lot of that IP into the public domain and did not continue to maintain those patents any longer. The other reason we might want to protect our IP is to protect a product or a brand. But we need to ask ourselves, why are you protecting that product and brand? What are you protecting it from? Do you not want somebody to copy a piece of artwork, for instance? IP protection gives you a limited period of monopoly under the law, and I'll come on to talk about the various timelines. Protecting IP via patenting or trademarking or whatever does not allow you to protect that IP in perpetuity. The other thing that we need to think about, and I'll give some examples of this, is we might want to just protect particular knowledge from third-party use. Now, why do we want to protect that knowledge from third-party use? Is it because that knowledge is culturally sensitive, for instance? And I'll provide some examples of how we may protect knowledge as we go through the webinar. So how can you protect your IP? So I'm just going to run through some of the more formal processes of IP protection and give you some examples. But before I start there, I want to just highlight a cautionary note. So we can protect IP through various formal or legal means, and I'll run through them in the talk. What protection of IP does, it acts as a legal deterrent to third parties to utilize, copy, reproduce, etc. Your piece of intellectual property. However, invariably third parties will use, copy and reproduce your IP, and we hear all the time about legal cases for patent infringement, for infringement of copyright, etc., etc. What this means is that if you have formally protected IP, okay, you own that IP, you've got the patent, you've got the copyright, you've got the trademark, whatever, you must be prepared to legally prosecute through the courts any breaches of your formal IP protection. The key point here is, as the owner of the IP, you pay for this. So any prosecution of IP breach, you as the IP owner or the organization you work for, if the IP sits with an organization, will be paying the costs of prosecuting that IP, and that can be very, very expensive. So that's another thing we need to think about when we're protecting IP, is down the track, we protected our IP, are we prepared to prosecute any breaches of that IP? If we're not prepared to prosecute, then we actually have to think very carefully about whether we want to formally protect that IP in the first place. So one of the easiest ways of protecting your IP is just don't release that IP into the public domain, okay? But it's really important, and Katrina provided me with a couple of examples of where questions have come up within Northern Institute about how can we formally protect IP that's already out there? Well, the simple answer to that question is if IP is out in the public domain, it is pretty much impossible to formally protect it retrospectively. So there's just a small quote here from a legal source. So basically, when we talk about prior disclosure means that that IP is already in the public domain. So, a piece of artwork, a poem, they're probably not the best examples, but anyway, but that is in the public domain. Okay, you cannot legally apply to register IP protection on that intellectual property once it's in the public domain. So the key thing is, if you want to protect IP, don't let it get into the public domain. Now, from an academic point of view, you're carrying out a piece of research, you generate knowledge from that research. One of the things you might want to ask yourself is there a market demand for the knowledge generated from your project? I.e., does that unique knowledge that you've generated provide you with the opportunity for things like commercial consultancy contracts? Now, I worked for many years in mining industry research, in mineral exploration and mineral processing research with universities and CSIRO in WA. And a lot of the time, the outcomes of that research wasn't released into the public domain, but was used as a means of generating consultancy contracts with mining companies. The issue there is you've got to, as an academic, you've got to balance your IP protection that may give you opportunity for commercial consultancy contracts with your academic performance expectations, which is publications in journals, citations, etc., etc. The other thing we might want to think about with research IP is your research IP may have greater impact if it is in fact released into the public domain. Okay, so you publish it in an academic journal, or it's a piece of, let's say it's a piece of software that you've developed or code you've developed, you just release that into the Creative Commons, that sort of thing. The other way we can fairly simply try and protect our IP is by entering into a non-disclosure agreement. So let's say I'm a company and there's a company over here and we want to work together, or an individual and an individual, we want to work together. I've got some unique IP that I want to share with that individual for the purposes of, you know, working together. What we can do is we can draw up what's called a non-disclosure agreement, which is a short legal agreement that binds both parties not to disclose IP to any other parties. An NDA provides you with the opportunity for penalties under law, which means that the party in breach can be sued by the other party. So again, you know, if somebody's going to take your IP and run away with it, you've got to be prepared to prosecute that second party. Now, what's an example here? Now, a possible example is cultural knowledge disclosed by one of your Indigenous partners for the purpose of a research project. They disclose that cultural knowledge to you. You have an NDA. It means that you, as an academic in Northern Institute, can't communicate that cultural knowledge without the disclosing party's permission. If this is something that you'd be interested in moving forward with, or may think that may help you with some of the work that you're doing, we've got Nda Templates here at Ori, and we can work with you, myself and Eve-Marie Cranmer can work with you in developing non-disclosure agreements. So here's just an example clause from a recent CDU NDA that we entered into, and it just provides some of the sort of legalistic text that is used in these sorts of agreements. So only permit the use of the confidential information for the purposes of the actual work you're doing together, not disclosed to any person unless permitted in writing, keep the confidential information secure, notify the disclosure if it suspects or becomes aware of any loss or unauthorized use. So that's just an example of the sorts of text within a non-disclosure agreement. It's a legal document and, as I say, prosecutable under law. So another way you might want to protect your IP is via a trademark. So trademarks protect an identity, so a business name, a corporate logo. Trademarks can also be used to protect things like corporate jingles, sounds, shapes. Coca-Cola, for instance, Coca-Cola, the unique Coca-Cola bottle shape is a trademark. Plant material, and even colors. If you come up with a new color, you can trademark that color. So when you apply to IP Australia, and there's a link at the bottom there, you apply for a trademark. An examiner at IP Australia will examine your application, and what they're looking for is, are the goods and services in the application clear? in the correct classes. Now, is your trademark similar to a previously registered or applied for trademark? Or for instance, is your business name similar to another business name? And so on. A trademark is only valid for 10 years. The other thing with a trademark is it's a case of use it or use it, or lose it. So if you register a trademark but then don't actively utilize that trademark in business or commerce or the work of your organization, that trademark will be taken off you. Example of the cost. So and this is from a personal experience. So previous company I worked for, we trademarked the company name and the corporate logo, so like the CDU logo here, and was granted an Australian trademark, and that cost about $3,500. The key thing with a trademark is it only protects you in the jurisdiction where you've registered that trademark. If you want to have international protection, trademark protection, then you need to register that trademark in the individual jurisdictions where you want to protect it. So example, I'll just give you an example of trademark infringement. Previous company that I worked for was actually was approached by a third-party company and accused of breaching that third-party company's trademark. The two companies used the same acronym in terms of their business name. The third-party company had trademarked the acronym back in the 1940s. The company I worked for had never trademarked that particular acronym for the company name. And this ended up in a 2-year legal battle and ended up in the company I worked for giving up the rights to use that particular acronym. And cost the company something not short of $200,000 to fight that particular battle. So people out there will especially large multinational companies, will very actively protect their trademark. Copyright. So copyright protects what's known as an expression of an idea, set down in a material form. So it doesn't protect information, ideas, concepts, styles, and methods. So in terms of the sorts of materials under Australian copyright law, known as Part 3 works, really we're talking things like literary works, musical works, artistic works, dramatic works, sound recordings, films, broadcasts, etc. Now, a copyright is only valid for 70 years from when the work is first published. After 70 years, that particular work goes into the public domain and anybody can use it. Copyright is free and automatic upon creation of the work. So, for instance, you're an artist, you paint a picture, you sign that picture, you are automatically awarded copyright over that piece of work. In general, the first owner of the copyright will be the author, so the person who painted the picture owns the copyright. Under Australian law, where an employee is the author, the first owner of the copyright is the employer. So if you come up with a copyright work as a employee of CDU, unless you've negotiated otherwise, CDU owns the copyright. If you want to get more information about copyright, go to this link here, www.copyright.org.au. It's very detailed, comprehensive information about copyright. So if you're a copyright owner, you have the exclusive right to reproduce or copy your work, communicate your work, publish, perform your work in public, or adapt your work, okay? If somebody else wants to use your copyright work, you can provide those third parties access to your copyright material through what's known as either assigning or licensing that copyright material. So by assigning your copyright, you transfer to a third party, which then owns it with all the rights deriving from the copyright. So simple example here would be you're an artist, you sell a painting to somebody, they buy that painting, they then own it. You have effectively assigned your copyright to that individual who's bought it. The other way you do it is by licensing your copyright. So again, you're the artist, you painted a picture, you have copyright on it, you enter into a legal agreement with a third party to allow that party to exercise some or all of the exclusive rights. So you might say, okay, I'm going to let you reproduce this painting as a series of prints, and for every print that you produce, you're going to pay me $3, and that's known as licensing. It's a legal contract. The key thing here is the use of your copyright material by a third party is illegal. However, all right, if the use of another's copyright material without the copyright owner's consent is copyright infringement. And this just gives some details here of what that means. But it is the onus on you as the copyright owner to identify that infringement. And then, as I mentioned right at the beginning of the talk, it is the copyright owner who will then have to commence a civil action in court against the third party that's infringed on his or her copyright. Okay, and the court, if the court finds that copyright has been infringed on, they will award various penalties. But again, you've got to commence legal action, you've got to get a legal team behind you, and again, you might not win. Excuse me. So licensing. So licensing, to license something, you must legally own the IP. So if you want to license the IP, you either have got copyright, patent, trademark, etc. And you enter into a legal agreement with the third party to use that IP. And then you can charge a fee or a royalty for use of the IP. Now, I think we're all aware of the current example with the Aboriginal flag. In terms of the artist has copyright, as I've already explained, automatic copyright as the author of the design, has been licensing some organisations to utilise that IP, but he's also not particularly happy that other third parties, and has certainly not assigned the IP for anybody to use. And yeah, we're all aware of the various discussions that are going on at the moment in terms of the use of the Aboriginal flag and the rights of third parties to use and reproduce the particular design. So just give you a case study in terms of licensing of Indigenous artwork. So this image here is a satellite dish in Alice Springs. It's owned by Geoscience Australia, the Commonwealth Government Geoscience Agency. Geoscience Australia wanted an Aranta artwork on their dish to pay respect to the traditional owners of the site in Alice Springs, and commissioned a piece of artwork by the local artist Roseanne Kamari Ellis. Some of you may know Roseanne, those of you in Alice Springs. So Roseanne produced the artwork. Geoscience Australia purchased the artwork, so effectively Roseanne had assigned her copyright to Geoscience Australia. But also what they wanted to do was they then wanted to reproduce the artwork or elements of the artwork. So the image that you've got here is not the complete artwork. Particular elements of that artwork have been pulled out the original painting and reproduced on the dish. So Roseanne licensed Geoscience Australia through formal agreement to reproduce particular elements of the original artwork, even though they purchased the artwork and effectively that artwork had been assigned to them. There was still a separate license for them to reproduce elements. So that's Roseanne protecting the integrity of her artwork. And this, the use of the elements from the original painting on the dish required the agreement from Roseanne, the author, the artist. Again, we've got licensing agreements that, you know, we have template licensing agreements, and you know, happy to talk to anybody who wants to come and talk to us about licensing agreements. But main thing about licensing agreements, you have to formally have protection of the IP through patent, copyright, trademark before you can enter into a licensing agreement with a third party. So really the final sort of key way that you could protect IP is through patenting. Everyone's heard of patents. So patents protect an invention, normally new solutions to technical problems. Patents have to be novel, okay, so new to prior art. They have to be inventive, and what they mean there is it's a non-obvious, and they have to have what's defined as industrial applicability, i.e. utility. So it's a drug, it's a piece of technology, it's a piece of software code, etc., etc. Patents, typical duration is 20 years. So for instance, when you go into the pharmacist and you know, you've been prescribed a particular drug and they said, do you want the original or the generic version? What happens with drugs is after 20 years, the original patent holder loses the exclusive rights to manufacture and sell that drug, and then any other company can come in and manufacture and sell that drug, and that's what's meant by a generic medication. Again, IP Australia website explains all of the different patent rules and the process that you need to go through. So what I'm going to do now is just give you a real case study of patenting of a piece of technology that I was involved with. So Centre for Appropriate Technology is a wholly owned Indigenous commercial not-for-profit company headquartered in Alice Springs. So one of the things that Centre for Appropriate Technology worked on is trying to provide better digital connectivity to rural and remote Australians, so these two maps here, these are the Telstra mobile phone coverage maps. This is Victoria, here's Melbourne, and here's the Northern Territory. So it's anywhere we've got green and brown do you get mobile phone coverage. There's a lot of people live in these areas. So the technology challenge here was, is there a technology, could we develop a technology that extends mobile phone coverage? So the people who worked at CAT came up with a sort of design criteria to develop a piece of technology that could extend mobile phone coverage. Now the key thing here is the initial design criteria also included a consideration is, does this have commercial product potential? And is it protectable IP? So right from the word go, before they even started to design the piece of technology, they were thinking about, well, can we protect the IP and are we going to make $1 out of this? So key tip here is you must, if you're looking at patenting or any sort of IP protection, think about how you're going to protect that IP before you actually start your project. Now, in the case of a patent, is there an identified market demand for the technology, the product, or the process? I'll just reiterate what I said earlier. Only consider patenting if you have a detailed analysis that there is a potential commercial market for your IP. If there's not a commercial market for your IP, you're going to be spending a lot of money for very, very little, if not any return. So this is what a mobile phone hotspot looks like. Some of you may have seen these as you drive around. There's quite a few up and down the Stuart Highway. So what CAT did was to develop a suite of pilot installations where they proved that the technology worked. They started to receive orders for further installations. They undertook a fairly detailed market research consultancy, and that gave them an understanding that there was actually a commercial market out there for this particular technology. So why did they need to protect their IP? Well, they obviously didn't want anybody else to copy the product, and they needed IP to be protected in order to enter into what's called a turnkey purchase. So a third party would say, right, I'd like you to install 5 hotspots in these areas. They buy the product, the company installed it. So the IP needed to be formally protected to prevent third parties copying the technology. And also another commercial arrangement was to license the technology to third parties. And again, the IP had to be formally protected before the company could enter into third-party agreements. So I just want to talk you through the journey, the patent journey that the Centre for Appropriate Technology went through. So the first thing that the company had to do was trademark the product name. So I talked about trademarks earlier. You go to IP Australia, you apply for trademark protection, and so Centre for Appropriate Technology applied for trademark protection to protect the name, the CfAT mobile phone hotspot. Now that cost $4,000 because it wanted trademark protection in more than one particular area. So first thing we did was to protect the product name. The next thing the company did was think about a cost-benefit analysis of protecting the product through patenting. So, thought about, well, what's the likely cost of achieving patent protection versus the revenue that's going to be received through product sales and licensing revenue. So, each of the different hotspots costs a certain amount of dollars. The company estimated the market, how big the market was going to be in the first 3 years. So had an idea of, what revenue was going to be generated through sales of the product. And then the company hired a very good patent attorney. You do not go through patent application or lodging a patent on your own. You need really good qualified patent IP attorneys to help you on this journey because it's very, very complex. It also takes a long time. So the company filed its original patent application in 2016, and the patent was finally awarded in September 2019. So it took about 3 years for that patent to be awarded. However, your IP, once you have applied for a patent, your IP is actually protected during that patent application and assessment process. So that's something important to think about. Now, the total cost of obtaining a patent in this case, legal fees, IP Australia fees, employee time, okay, a lot of the people in the company were involved in the technical details of the patent, was nearly $100,000 to achieve that patent. So it's not cheap. The other thing is you've got no guarantee your patent will be awarded. So you are taking a bit of a commercial gamble if you're wanting to protect your IP through patenting. And then the annual fee to maintain a patent, and I referred to this earlier with the example of CSIRO, is there's an annual fee payable of $8,000. If you don't pay that annual fee, your patent lapses. And basically that's, you've got no protection now. Somebody can just go out and copy or reproduce your particular product. Now, in the case of the Centre for Appropriate Technology, it made the decision that it was only going to apply for a patent in Australia. And I go back to my previous comment that only formally protect your IP through the various mechanisms that we've just briefly run through if you are prepared to prosecute infringement. So the decision that was made by the company was, well, we're prepared to actually go to court and prosecute somebody if we find out that they're copying our product in Australia. Are we prepared to do that in places like Vietnam, Indonesia, Thailand, et cetera, because there was certainly a big market for the technology in those other jurisdictions. But the issue there is there's no such thing as an international patent. Okay, you have to apply for a patent in all of the individual jurisdictions. So if a company had wanted to patent protect this particular technology, for instance, in Thailand, it would have had to have gone through the whole process of patent protection and the cost of getting a patent granted in that particular jurisdiction, and then be prepared to prosecute infringement in that jurisdiction. And the decision was made. This is it was a small Indigenous not-for-profit company. It just didn't have the resources to do that. So that's why the decision was made only to protect the IP in Australia. The other thing to remember is once your patent is granted, your IP is actually in the public domain. So you or I or anybody can go into IP Australia. We can look up all the Australian patents. We can get the detailed technical documentation. So everybody knows your secrets once you've got a patent. Patent applications I mentioned earlier, and this is where a lot of the cost is. They're very detailed technical documents. Excuse me. Very detailed technical documents. This particular patent was 37 pages, lots of complex figures, and very detailed technical, and this is what your patent lawyer does. There's a particular language that none of us speak in real life that is utilized in patent documentation. So this is where you get the value from your patent attorney. You've also got to be prepared for disappointment. As I said earlier, there's no guarantee that your patent is going to be there's no guarantee that your patent is going to be granted. And in fact, in the first instance, the Centre for Appropriate Technology's patent application for the hotspot was actually rejected by the patent examiner. Basically came back and said, it doesn't involve an invention, it's not novel, there are examples of prior art out there, etc., etc., etc. If your application is initially rejected, you do have the right to reply. So the company went back, they prepared a formal detailed technical response citing prior art, etc. With the patent lawyers, submitted that back to IP Australia. So you have the right to reply. And then they accepted that, and the patent was accepted as I mentioned earlier, in September 2019. Once your patent has been accepted, it doesn't necessarily mean you're going to be granted. What happens is they accept your patent saying, yes, it's novel, it's innovative, there's no prior art, etc., etc., etc. But then that patent goes up for 3 months of public examination. And during that 3-month period, anybody can go in and appeal the granting of patent, saying, actually, no, this is not right. I've got a particular technology that I developed and I've patented, and it's very similar to this. So acceptance is not the end, but anyway. And I believe the patent was granted after I left the company, so that's pretty good. And so what did it mean in terms of the business for the company? Well, 47 hotspots were sold up until the end of 2019. So in terms of the cost benefit, the cost of IP protection, so what I've just talked about going through the patent, the cost of IP protection was equivalent to about 9% of the sale revenue. Okay, so it gives you an idea of the cost benefit there. So plenty of hotspots along the Stuart Highway and various other places, a lot on remote Indigenous communities, mainly in Central Australia, a few in the top end. So that's just an example, and happy to talk to anyone about this, or if you're interested in patenting in the future. So in summary, and oh, look at that, 39 minutes, how's that for timing? In summary, really important to understand that once your intellectual property is in the public domain, I'm saying almost impossible, but probably is pretty much impossible to formally protect that IP through legal means. Formal IP protection is often costly, time-consuming, and complex. So you need to really understand what is the cost benefit of formal legal IP protection. The other thing that, just to highlight again, that all forms of IP protection from a simple non-disclosure agreement to patent require the IP owner to be prepared to exercise their legal rights, i.e. prosecute anybody that infringes on their IP, and obviously have the resources to do so. Sometimes, it might be useful to consider what, less formal means of protecting IP. Don't release it into the public domain, simple non-disclosure agreements, etc., etc. And these are sorts of things, I'd be very happy to talk to anyone about if they're thinking about, they've got some IP that they want to protect, or they don't want to get it in, they don't want it to get into the public domain. So yeah, if you're thinking about IP protection, come and talk to Ori, come and talk to us. We're here to talk to you. We're here to help you. So yeah, there's my contact details, but you can just look me up in the CDU intranet, and always happy to talk to people about this sort of thing. And thank you, and happy to answer any questions. Cheers.
I just wanted to say thank you very much. That was really, really informative, certainly for me, and I think for quite a few people that that have attended today. One relates to copyright for music. So the question is from Kane, and he mentions that he thought that copyright for a song lasts for the artist's life plus an extra 50 to 70 years.
That is correct. It's the artist's life plus 70 years. That's correct.
Okay. And there's another question from Simon, and he says, do you think some IP at CDU, especially around branding and Indigenous products, could also be more protected by design rights rather than trademarks or copyright, given that design rights relate more to configurations, shapes or patterns that confer a unique appearance?
Yeah, so if you go onto the copyright slide, I just skipped that over, but we did talk about design rights. Yes, certainly, I think, given the facts that design rights are, as Simon said, their configuration, shapes, patterns, etc. Yes, they could be, but again, you've got to be prepared to prosecute any infringement of that design rights. The other thing about design rights, my understanding is that particular IP needs to be in production. So let's say, you've got a design right for a dress material. You need to be producing dresses, commercially that are using that particular design. But as I said, I'm not an IP lawyer, but yeah, design rights, certainly agree with that. But again, you need to be prepared to prosecute.
Thank you. And can you see there's a comment there? Yes?
Yeah. Government-funded research often purports to vest IP in, for example, the Commonwealth. This is a huge problem for research in the Aboriginal domain. So are NDAs a solution, and would government accept their existence? Happy to talk to you about this, Chips, because yes, I think we've all been faced by this in a number of projects, and I think when you're in the process of negotiating contracts, then I don't see any reason why you shouldn't be saying to the Commonwealth, yes, okay, the IP vests in the Commonwealth. However, there are particular elements of that IP, especially when it comes to cultural knowledge, that are not going to vest in the government, and we want a non-disclosure agreement. So it's worth a try, Chips, and happy to talk to you about that. A new music video is on the YouTube. What happens with a copyright issue? Can anyone use the content of that? I'm not really sure. Certainly, if a band, a group puts a song up on YouTube, you then perform that song in public, you're infringing on their copyright and public performance rights. Yeah, that would be my answer there. Yeah, Phil's raised the question about moral rights. Yeah, that moral rights is an interesting one, and I've got to admit it's something I don't know a great deal about. So, Phil, you might know more about it than I do. Kelly, if you share an idea to develop into a digital app, can you protect your idea before it gets fully developed and ready to be published? I think I'm just trying to work out why you'd want to protect the idea. I mean, the way you'd protect your idea would be to not disclose your idea. I mean, that would be my comment on that question. I mean, you know, if you're developing a digital app and you've got thoughts and ideas, just don't put that into the public domain. The only time that the product goes into the public domain is when it's fully developed, ready to be published. And at that stage, one presumes that you have some sort of formal IP protection. But yeah, simple way to protect an idea, don't tell anybody, don't put it in the public domain.
Anthony Hornby,
Anthony,
from the CDU library, has mentioned that the library can provide specific advice and they can be contacted. I think that's the end of the questions for today. Thank you, Steve, for joining us. I really appreciate it. That was really helpful. And yeah, thank you very much for doing a webinar for Northern Institute today.
Thanks.